Hi everyone, my name is Allison Grosz. I'm an attorney and a partner at Hemrick O'Malley, PLLC here in New York City. Today I want to talk about religious workers and whether or not a religious worker is allowed to be employed here in the United States because of their status as a religious cleric or in a religious vocation. So, there are two separate kinds of religious worker statuses here in the United States. One of them is a non-immigrant religious worker that gets a visa called an R1 visa. Their family members are eligible for R2 derivative family member status. The second kind of status would be an immigrant religious worker petition. Now, this is for a green card or permanent religious worker status. For purposes of today's video, we're going to be talking about the non-immigrant R1 visa status, and in another video, we are going to go over the details of the requirements, eligibility, and other criterion for the permanent green card religious worker status. So what is an R1 visa? An R1 non-immigrant visa is for an individual who is coming temporarily to the United States to be employed solely in a clerical, ministerial, or religious vocation. Now, in addition to those requirements, there are, of course, some other requirements other than just being a cleric or in a religious vocation. Some of those requirements include that the person must be solely employed as a minister, cleric, or in a religious vocation for the petitioning religious organization here in the United States. That petitioning religious organization must be a qualified religious organization here in the United States, meaning that it is a qualified religious denomination or organization that is holding or affiliated with an organization that has 501c3 nonprofit status. The R1 non-immigrant religious worker must also be designated to work at least 20 hours per week for the religious organization that is petitioning for them. In addition to that, the R1 visa holder must have been a member of the bona fide nonprofit religious organization or denomination for at least 2 years immediately preceding the organization's filing of the petition. It's important to understand that an R1 visa holder cannot petition themselves for the R1 visa. The petition is required to be filed by the designated bona fide nonprofit religious organization or entity here in the United States on the R1 visa holder's behalf. Now let's talk very briefly about who would be qualified for an R1 visa. As I said previously, it would be somebody who is a designated and qualified cleric or minister within their religious organization or denomination. But in addition to that, people who have a religious vocation also qualify for an R1 non-immigrant visa status. Now, what is a religious vocation? A religious vocation is for someone who is not necessarily a cleric or a minister in their religious denomination, but someone who promulgates or furthers the petitioning religious entity's religious goals, meaning that this is a religiously oriented position. A religiously oriented position has been determined to be many different things. For instance, a religiously oriented position can be somebody who is, for instance, doing tech support for a church, if that tech support is solely in the capacity of working toward the religious entity's goals. In some instances, it can also be somebody who's doing marketing or other sorts of professional work on behalf of a religious entity, as long as that professional work is solely promulgating or furthering the goals of the religious organization or entity that petitioned for their R1 status. Now, it's really important for R1 visa holders to understand that they have to be solely working for the religious entity that petitioned for them. They cannot be working for any other organization or entity here in the United States. This is not a free-for-all work authorization. It is strictly in the furtherance of the religious organization who filed the petition. In addition to that, the religious worker cannot be volunteering for any other religious organization or for any other group or organization or entity, because unpaid employment, i.e. volunteering, counts as unlawful employment for these purposes. It's also important to note that a R1 visa holder who has qualified R2 family members who can get derivative status are not allowed to have those family members work here in the United States, meaning that if somebody's here under R2 status, those family members cannot work here in the United States and also cannot volunteer here in the United States, even if it's for a religious entity. Lastly, and very briefly, somebody holding an R1 visa petition is qualified to hold that R1 status for up to 60 months. A person would get an initial 30-month period, and of course, that can be extended for an additional 30 months. Now, of course, any time spent outside of the United States would be able to be recaptured by the R1 visa holder so that they can get a total 60 months here in the United States under R1 status. With that being said, us here at Hemrick O'Malley, PLLC, love to work with various religious workers. We represent religious entities, churches, ministries, and all sorts of religious denominations from all over the world. We're happy to answer any questions that you have about whether you are a qualified religious organization or denomination that can file a petition on behalf of someone. We're also happy to answer any questions about whether someone is a qualified beneficiary or a qualified R1 visa holder. You can feel free to find us online at hemrick.law. You can also call us at 833-848-7838. Of course, in addition to answering questions about religious workers, we're also happy to answer any other questions about other immigration matters. We look forward to hearing from you soon. And until then, everybody have a great day.